Good afternoon and good morning. Welcome back to the Virtual VETS'20 webinar series. Today is the final webinar of our 18-part webinar series hosted by the National Veteran Small Business Coalition. I'm Earl Morgan, the program director, and to our new attendees, thank you for joining us today. I'd like to thank our 8 sponsors who made this webinar series possible. Today's runtime is 1 hour and is being recorded. If you have any questions for this webinar, please type it in the text box on your screen. We will try to get to your questions, all to your questions today, and if we're not able to get to your questions, we will post the answers on our virtual VETS webpage. I'd like to introduce, for the last time, the Executive Director for the National Veteran Small Business Coalition, Mr. Scott Jensen.
Thanks, Earl, and good morning and good afternoon to everyone out there across the United States. It's great to be here again with you this week, and it might be for the last time in 2020, but we look forward to starting up a new series of webinars in 2021. And I would just like to take a moment to thank Mr. Earl Morgan for all the hard work that he has put into this series of webinars. No one could have expected when we started the year that we would have to cancel our in-person VETS'20 and the ongoing impact that would have with our training and education opportunities. And Earl has really leaned into that and solved that in a very positive and effective way. And we sure appreciate his hard work and his commitment to the work that we do here. So thanks, Earl. We appreciate it.
Thank you.
You bet. Today, it's my pleasure to introduce our final guest and someone close to MVSBC, very near and dear to our hearts, Sarah Rada. She's an attorney who works almost exclusively with veteran small businesses competing in the federal space, one of the country's leading authorities on VA VetBiz verification requirements. Her common sense handbook on verification is used by many to navigate the VetBiz process. She's experienced in status protests, claims, compliance issues, and in government contracts litigation before the appeals boards and GAO. Most recently, she represented VETS'20 Inc. in its sustained GAO protest protecting veterans' rights under the Kingdomware precedent. Sarah is a dear friend of ours, as I said, and works closely with MVSBC and our members, and we certainly appreciate every time we get to interact with her, and today is no different than that. And Sarah, thanks for being with us. And with that, I'll turn it over to you and let you get started.
Thank you, Scott. That's really nice. I'm excited to be able to work with you for the first time in this kind of interactive experience since you took over in your executive position. So this is fun. I really appreciate everything that MVSBC has done for me, and I'm honored to be a part. So thank you very much for letting me present the last webinar the day after election, or I suppose it's not over yet. So
That's
this
right.
particular timing of this presentation is a little bit interesting. But basically, I asked to present on this webinar because I am an attorney who works with veterans who compete entirely in the federal sphere, and I have been getting a lot of really strange, nuanced questions relating to coronavirus. And the reason why they're strange has nothing to do with really the nature of the issue, but the fact of the matter that coronavirus is just such a novel issue. We've never had a global pandemic. We haven't had certain situations that have cropped up because of the global pandemic. And the reality is that the federal acquisition regulation and to an extent, some federal contracts don't really address what should be done, what should be equitable in the instance of dealing with the effects of pandemic. So the point of this particular webinar is to be, first of all, proactive in dealing with what can happen because of the effects of coronavirus, and to know your legal rights and remedies in the instance that you are affected by the pandemic. I'm also going to touch a little bit on bidding and how to account for pandemic, just in terms of knowing what is something that you can recover for and what you can't, just in terms of just things to expect and best practices, because the purpose here is to give you all the tools you need to where if you're competing in the federal marketplace and you have a question, you'll be able to know where to look based on some of the resources and the legal authority that I've cited. And keeping in mind too, again, that this is novel. There has not yet been a board decision on coronavirus in terms of how the pandemic has affected a contractor and its contract performance, the contractor wanting an extension or more money. I mean, it just hasn't gotten there yet because it's that new. So this is uncharted territory. So we have to just be proactive in protecting ourselves. So first slide, please, Errol. So program objectives I've already covered, so we can just go ahead and skip this one. And the next one is, so let's say you have pandemic performance issues. The ones that I've been dealing with most frequently relate to service contracts. You have people not showing up, you have social distancing, you have different government orders that are in place for the state in terms of what can be done in terms of things that will impact your contract performance. And because of that, it's caused a lot of delays in performing service contracts. And so the first thing that you would do if you are experiencing a delay in performing a contract is to check for these two clauses. So there's one for cost reimbursable contracts, and then there's one for fixed price supplier service. And so these will protect you in the instance that you are technically in default because you are feeling the effects of the pandemic. So a contractor is not in default as a result of causes beyond the control and without the fault or negligence of the contractor or a subcontractor, provided that the subcontractor is experiencing the similar kind of pandemic effects that are beyond its control. And quarantine and epidemic are listed as examples. These are similar to force majeure clauses that you would find in commercial contracts. They're pretty common in normal commercial contracts in terms of one party can't be held to be in default if there's something beyond its control. And it's usually embargo, strike, government shutdown, and pandemic is usually pretty common for this. And so the rule of thumb here is that if pandemic makes you default under the contract, you can be held to not be liable, or if there is a delay, to not be liable for that delay if you're able to show that what has happened is excusable, or if it's an excusable delay. And that is discussed more on the next slide in terms of what an excusable delay is, because one common misperception that I've seen as a contractor is if it's pandemic and if it impacts the contract, then you automatically get not a get out of jail free card, but that's your reason for getting either additional costs, or that's your reason for being entitled to additional time. And it's not as automatic as you would think. There are actually standards that you have to meet. And so even though the FAR says excusable delay, you won't be liable, in order to show excusable delay, because it's a legal term, of course, it is subject to definitions. And there are, I believe, 4 different elements that are discussed on the next slide if you're going to be able to show that whatever has happened to you because of the pandemic is feasible or is excusable. Earl, can you go to the next slide and then we'll flip back to this one, because the next slide is the one that has the elements. Actually, I guess it's the next slide after that. Sorry about that, Earl. I'm just looking for the one that has elements on it, where it talks about excusable delay, and then we can go back to the other 2. Okay. Well, I have them anyway, so we can discuss them as they are. So there are 4 different elements if you want to show that whatever has happened because of the pandemic isn't your fault. And the first is that you have to prove affirmatively that the delay was caused by or arose out of a situation that was beyond your control. So basically, it's the pandemic. And it's not just that it was the pandemic that caused this, it was something about that impacted your performance. So say, for example, I'm going to use a grounds maintenance contract because I feel like that's the most basic in terms of something that can be impacted by the pandemic because of how it would affect people showing up to work. So the first thing would be, are people not showing up to work because of quarantine restrictions or because of issues with social distancing or other kinds of directly tied to pandemic issues? If that's the reason, then you can show that it's an excusable delay. That first element can actually be a little bit tricky to prove, because the thing is that excusable delay has to only be caused by the pandemic. So if you have some other problem, like say, for example, you have a workforce that is a bit dodgy anyway, and they aren't showing up, or say you have inclement weather that has caused you from not being able to perform on time, and your contract specifically says inclement weather isn't an excuse. If you have some kind of a concurrent cause along with whatever has happened because of the pandemic, it could be found that the delay wasn't excusable, that sure, the pandemic did contribute to it a little bit, but ultimately the only cause of the reason why you defaulted or why you were delayed wasn't the pandemic. And then if that's the case, then you can't show excusable delay. So it is really, really important early on to say, okay, look, the pandemic is beginning to affect us, or this is going to happen because, you know, like for example, I'm in Illinois and everything is shut down all the time. And so we'll be getting advance notices that, you know, on Friday, we're going to have no indoor eating in restaurants. And so with the pandemic, even though some of these situations are unpredictable, we know what's coming to a degree. So as the contractor, it is crucial to be able to track anything that could come because of the pandemic and be able to document it in writing. You know, say, okay, you know, we know that there's been another outbreak or there's been a surge and this is how it's affecting us, and just keep a log, keep a contemporaneous log as to what's happening. Be in constant contact with your contracting officer and officials to basically show them that A, it's not your fault, that it's the pandemic and it's only the pandemic and what the pandemic is doing. B, that you're doing what you can in order to mitigate any effects. And then C, that you're also keeping track of any contemporaneous impact on you. Because that's the thing, if you can't prove that it's the pandemic and the pandemic only that is causing this excusable delay, then you're sunk from the outset. And so that's probably the most essential element of the 4-part test to keep in mind, and the fact that just be very, very careful about written documentation and being in contact with your contracting officer. Then the second part is that you have to show that your performance would have been timely if not for the excusable delay. And so this can be a little bit more of a gray area because sometimes it can be hard to show that. I mean, how can you show that you weren't going to be timely or that you're going to be timely? I mean, it seems like in a lot of instances, it would probably be that there's no evidence that you wouldn't have been untimely, that, you know, you kept with your schedule. And just in general, what you would need to do in order to show that you would have been timely, that you wouldn't have otherwise defaulted, is written documentation. I mean, that's really the key here. As contractors, we know that in general, that's an extremely important rule of thumb, is making sure that you have contemporaneous written documentation of everything that's occurring in the contract. So first of all, it's beyond your control. And second of all, that you wouldn't have defaulted or been late after or anyway. And then the third element would be to show that you took every reasonable precaution. So say, for example, and that's another issue too, is that what is a reasonable precaution? Because in a pandemic, you know, I deal with a lot of small business contractors. You can't afford to hire a workforce that's 50% bigger than your workforce needs to be, and then have these people on payroll just in case the pandemic has other people not showing up. And then you can't have more people showing up anyway because of social distancing and having too many people in a room. It's been a bit of a mess. And so the rule of thumb is what is reasonable. And so again, the written documentation of, okay, you know, just so you know, we are expecting the effects of the pandemic, or this is what's been happening to us. So this is how we're taking precautions. This is how we're mitigating. And this is why it makes sense under the circumstances, because it boils down to whether or not it makes sense under the circumstances and whether you're doing the most that you can. You don't have to go above and beyond to put yourself out of business to try to deal with the effects of the pandemic and how it'll affect contract performance, but you have to do what would make sense under the context to mitigate the effects. And then the fourth element, which can be a little bit tricky, is to establish that precise period of time that the performance was delayed. So say, for example, you have a 14-day cycle time. So you have 14 days that you have to cut the grass, or you have to perform grounds maintenance services, or just do something that is a service deliverable under the contract. It can be hard to show the specific number of days and when that occurred. So you basically just have to do the best that you can under the circumstances, because under these cases and under these elements, they don't expect a contractor to do the impossible, but you have to do what is possible, which I know sounds kind of funny, but I mean, it makes sense in the context where you just be prepared, expect the worst, or what is it? Expect the best, be prepared for the worst. And in trying to figure out how to deal with the pandemic. So what you do is when you have a time period of performance, try to pinpoint, okay, based on the pandemic, we had an extra 5 days that were necessary to perform, but we managed to get it down to 3 because we took these mitigative steps. And again, everything documented to your contracting officer. Try to get the best relationship you can, because the better relationship you have, obviously, with the contracting officer, and the more they like to work with you in your firm, the more they're going to work with you on excusable delay. And so when you show excusable delay, Earl, can you go back 2 slides? I believe that's where it would pick up. When you show excusable delay, what you're entitled to is you are entitled to a no-cost time extension. And so what I would recommend that you would do in these kinds of instances where you're going to be delayed, you're going to default under the terms of your contract, is to immediately tell the contracting officer what is going on and what you know, because you're not going to know everything. I give the example of a 14-day cycle period. Okay, well, how are you going to know 5 days in how exactly it's going to affect you? You're probably not. You're not going to know how late you're going to be until 3 days after the period ends, and that's when you deliver your product or your service. It's going to be hard to pinpoint it, if not impossible. And so what you should do in these particular instances under the default and the delay clauses is say immediately, I'm impacted by COVID. Here is how I'm impacted, and just lay out the elements. Do it as soon as you can and say, we're asking for a no cost time extension. Can we talk about this? Because the reality of the situation is that you're not going to be able to show them how many days precisely that you'll need for a no cost extension, but by establishing that dialogue early on, you're not going to get, hopefully, a show cause notice from the government, or a termination for default notice, or a cure notice, or anything else that can either affect your status on the contract or your CPAR rating. From what I've seen across the board is that no one knows how to deal with this. If it's the contracting side or the contractor side, there are just problems just because it's a novel situation. On the contractor side, you have people who just want to make the contracting officer happy. They don't want to admit to having any problems. They want to find workarounds. And that's great. And to an extent, if you can find a workaround, that's fantastic. But don't do it without the contracting officer knowing and approving, because if something goes wrong, then the reality is still that you have these contract terms that you haven't followed, or you've been late on a delivery, and that's really what matters. So just from the very beginning, just keep in contact and try to find the solution with the contracting officer, because in general, as a rule, I have seen contracting officers being a little bit lenient, a little bit generous in missing deadlines with COVID, just because that has been the nature of the game since the pandemic. With that being said, that's no guarantee that they're not going to enforce these clauses. They're legally allowed to if they're in your contract. If you are subject to default, that's a legal possibility. But the point is that if you have the good relationship with the contracting officer, and also if they know that if you're gone, nobody else can perform the work, you're the contractor who has been tasked to perform it, the main rule of thumb is to just find the solution. And the best way to find the solution is if you exercise your rights early on and you tell the contracting officer about what's happening with the pandemic and your proposed solution by way of a cost, not a cost adjustment, a time extension. Now, some clauses, so first of all, I noted those initial FAR clauses. So you first look at those FAR clauses. If you're going to default, if you have problems, see if your contract has those. If your contract does not have those clauses, you would probably want to look to FAR 52.214-4. This is the one for any commercial items. If you're looking at a FAR Part 12 supply or service or supply contract in particular, this has similar language relating to excusable delays. It also has some more nuanced requirements in it. So for example, the next one, Earl, the other one is the default for construction. If you are a construction contractor, that would apply to you. But the one that's the 52.212-4, that requires the contractor to notify the CO of excusable delay as soon as possible. It is not a deal breaker if you don't do that. There's case law out there that says that it's not a deal breaker that you act in the moment, and there can be cases where that is okay, that you have not immediately informed, but just try to do that as a general practice rule of thumb. And then it has other requirements, which is that you give them the details as to cause, you remedy such occurrence with all reasonable dispatch, and then you notify the CO of the cessation of such occurrence. And just from looking at that, you can tell that sometimes that might not be practicable, because you don't know how long the effects are going to last. If they stop, if you don't know if the pandemic is going to result in additional effects. So that might not be something that you can always do to the fullest extent, but you would do it to the greatest extent that is possible under your particular circumstances. And one thing that I have seen the government do since the pandemic, which is really just frustrating to see, is that under this particular FAR clause, the government may seek an equitable resolution instead of terminating for cause, because you are allowed to be terminated for cause for late delivery under this particular clause. So they don't have to give you a show cause notice. They can just terminate you for late delivery. But one thing that the government can do instead is to have an equitable resolution. And I have seen it where this poor contractor performed outside of the delivery date, and the government's equitable resolution was to just not pay him anything for any of those days outside of the original performance period. And that's pretty common in terms of just resolutions that the government chooses. And why did the government choose that versus having the contractor provide a 20% discount? Why not have a teleconference to discuss it? And so if the government unilaterally does something like that to you, a lot of times you cannot do anything to fight it at the time. However, one thing that you can do is, first of all, make sure that if the government goes and has an equitable adjustment and basically gives this big price adjustment or does something else that you don't consent to, but you don't want to be terminated for default and you also want the money under what you have done, is A, and this is critical, make sure that you don't waive your rights. If there's any modification that they issue, if there's anything that is a release, be very, very careful about consenting to it, because if you release your rights, then you might not be able to file it as a claim later. A lot of times you're in a hard position, because if they say, okay, if the termination for default clause applies, we could just terminate you for default, but we'll be kind and just give ourselves a 40% discount. What do you do? Because you don't want to take a termination for default. It's not fair for you to have this big discount. But at the same time, you find yourself in a bad position. So just when you find yourself in that kind of position, just be very, very careful to make sure that you're treading as carefully as possible and protecting your rights. Because what you can do is, if they give themselves that kind of a discount, you can always submit it as a claim later. You can show that, look, we met the requirements for excusable delay. They should have given us a no cost extension. Here are the reasons why we meet these 4 elements. And then if it occurs later in your contract, perhaps you could maybe do it at the end of the contract performance, or you could do it as a claim during contract performance, just depending on what makes sense based on the logistics of how you're performing. But just know that if you're performing a commercial items contract, that is something that they can do. They can say, we're not going to terminate you, but we're going to give ourselves a discount. And if that's the case, make sure that you have protected yourself adequately and you know what you're required to do and what you're allowed to do. So next slide, please. So we've covered the elements to show excusable delay. So we'll go to the next one. But one question that I've gotten a lot is whether there's been any case law yet on delays, how to handle this. What are some examples of something to apply to a situation to get a contracting officer to go your way? I mentioned in the very beginning of this, there have been no COVID cases yet. I actually checked Lexis, which is our legal database for decisions, just yesterday, and I don't see anything. And the reason why is because in order for a government contracts board to have jurisdiction over a claim, the way that it works is that the contractor files a request for a final decision with the contracting officer meeting certification requirements. And then the contracting officer has to either grant the claim in whole and in part and act within that in 60 days. And if not, it's a deemed denial, and then they have 90 days to appeal. So automatically that's about, I'd say, a 5-month lead time, because I mean, people usually don't want to file appeals right away. So you usually are dealing with a 5-month lead time at least. And then it takes a while for it to get through the Civilian Board of Contract Appeals, or the Armed Services Board of Contract Appeals, that can be another, 8 months at least. So I don't expect us to see any COVID cases in the near future, but I'm expecting to have a rash of them in 2021. All of a sudden, we're going to have a lot of cases that deal with these issues, just because it took that long for them to get through the process. But unfortunately, that doesn't help you now, because you need things to cite to now. So what I found are cases that are similar in terms of dealing with pandemic. And the one that I found that seems to be the seminal one on excusable delay is ASA L. Shipman's Sons. And if you are dealing with a situation where you're delayed because of pandemic, or you just want to be prepared, this is a good one to just pull. You can find it on the internet, where the contractor was unsuccessful in trying to get out of a termination for default because of alleged effects of the epidemic. The board ended up finding that even though flu was a problem, it wasn't the cause of the performance. So even though it might impact you generally and globally, if it's not flu that's causing the reason why you were late or why you weren't able to perform, then if the government terminates you for default, then that's not going to be found in error. So when it comes to performance issues, it's just so important to tie it directly to the pandemic. The pandemic made people sick, people didn't show up, we didn't have enough people to perform, the direct line of what happened. Because if there's any other cause, anything intervening, then it's not an excusable delay caused by the pandemic. And then the only one that I've seen, and I've seen several blogs on this one, is the joint venture case of Pernix Circa joint venture at the Civilian Board of Contract Appeals. This was actually decided just in April of 2020, if I remember correctly. And this is one that I'm sure everyone is interested in, because it talks about additional costs. And this is unfortunate, because another question that I get fairly frequently is, can you get additional costs? Because when you're performing, it's more costly, obviously, because you're dealing with pandemic effects, because you have to not only account for that, you have a reduced workforce, you probably have a lot of issues with employee retention, supplies. There might be issues with the supplies necessary to perform the work, the equipment. The unfortunate truth is that if it's a firm fixed price contract, the contractor assumes the risk of unexpected cost not attributed to the government. So unless there's something in your contract that would shift that risk to the government, which there generally is not, if you end up encountering additional costs in a firm fixed price contract because of pandemic, you're not going to be able to go after the government for additional costs. And in that particular case, they were looking at additional costs because of Ebola. And it's a really interesting case because it discusses the different impact of Ebola and how the contractor's prices and costs had increased. And it goes through why the contractor wasn't entitled. So if you're in the situation where you are encountering increased costs, it is a good one to look at, just because it shows you what you can and cannot do before you spend the time and effort and legal expense on going after costs. But always examine your options, because there are options out there, and there are numerous bar clauses that come into play here. And there is one particular cost that can be compensated, which is the next one. So next slide, please, Earl. These are practical considerations. I've covered them already. Look at the elements carefully. And as I've said, communication is key, and then request a schedule adjustment as soon as possible, including the reason for the need and the adjusted time frame. Just be as detailed, be as clear, and be as just detailed and clear and in writing to your contracting officer about what's happening with the pandemic, because you want a written record, you want a contemporaneous record, and you want to track your costs and what's happening. So that way, if it becomes an issue, if you're terminated or if something else happens, you have the written record that you did everything that you could. So that leads to the next portion, which is about actually recovering costs in the event of pandemic. Now, as mentioned before, and as was in the Civilian Board of Contract Appeals case of the Pernix joint venture, excusable delays usually don't get you more money. What they give you is a schedule adjustment, not a price adjustment. But there is some wiggle room, in the sense that there are some exceptions, and it's not when it's an excusable delay, it's when there are other things that come into play. So for example, if there's a stop work order clause, and if the government enforces a stop work order, like say for example, because of the pandemic, the government facility where you would be working shuts down, and so they have a stop work order, then that is something where yes, the pandemic caused it, but the government is the one that made the decision to shut down the facility. And so the government is the one that issued you your stop work order. And if you incurred additional time or cost in the interim because of the government issuing a stop work order, because the government decided to issue the stop work order based on its own actions, then that can be something that is compensable for what happened in the interim period. And then the second means of recovering additional cost is constructive acceleration. And I've harped in great length in the earlier portion of this about how important it is to be proactive, meet your elements, keep a written record, talk to your contracting officer, et cetera, et cetera. And the reason for that is because if you're able to do that, and if you're aware at the onset of the different things that can happen because of the pandemic and what your legal rights are, you might be able to get a claim for constructive acceleration in the event that the government doesn't work with you. And that is something that has been happening to a degree because these contracting officers are so inundated with issues, they're not dealing with things as quickly as they should. And, you know, part of it is government fault, part of it is we've never dealt with this before. But basically the way that that works is that if you have an excusable delay and you tell the government from the beginning, look, I have an excusable delay, here's why I have an excusable delay, can you give me a time extension? And the government tells you no, and they hold you to the original schedule, and you end up going out and buying more bulldozers and, you know, getting more people on your contract and doing whatever you need in order to meet the schedule, even though you really needed a time extension in order to do what you needed to do, the government can be liable for additional costs because it should have given you that schedule extension. So I'll talk about these in a bit more detail in the next slides. So the stop work order clause, which is the one at 52.242.15, next slide, please. It is the clause where it relates to the contractor being told to stop by the government. So in that particular case, it's not the pandemic that is causing the stoppage, it's the government. So the government actually took the affirmative effort of closing down a facility, embargo, just whatever the government has done to stop work. And so they issue a stop work order, and those can be for up to 90 days. And so if that's the case, anytime there is a stop work order, and this applies to just any contract, it's not just necessarily the pandemic, you can be allowed to have an adjustment to cost or time if it's equitable. And if the stop work order is the reason for the increase in the contractor's time and cost. Like, so say for example, if it was a government facility that was shut down and you're paying for an equipment rental for an additional 90 days or however long the stoppage was, then you can recover your equipment costs. And again, timing is key for this one as well, because the rights under the stop work order must be asserted within 30 days of lifting the stop work order. So once the stop work order is lifted, you have to make sure that you give them written notice that you're pursuing your rights under the stop work order. And then the next way that you can pursue costs is in relation to constructive acceleration. So next slide, please, Earl. And this is when, as mentioned before, when the government demands compliance with an original contract deadline, despite there being excusable delay. This is something that can be under the changes clause of your contract, where the government is basically requiring you to put forth more effort, even though you had an excusable delay that should have been properly addressed. So in that particular instance, you're entitled to reimbursement for expenses actually and reasonably incurred in complying with the acceleration order. So they tell you, nope, we're not going to give you an extension. You're going to stick with the original delivery time. If you have additional time in cost, then you can be entitled to an equitable adjustment. And there's a really good case on this if you find yourself in this situation, which is on the next slide. And that case is, well, first of all, the elements to prove on that are you have to prove the excusable delay under the contract. And as we covered, those are those 4 elements before. And then you also have to prove that you timely and sufficiently requested the schedule adjustment, that the government either denied it or failed to act in a reasonable time, and that the government insisted on completion shorter than the period to which you should have been entitled, and that you incurred the additional time and cost. And so that case that discusses this, and this is just a good one if you need an example, if you find yourself in a situation, that's the case that's on the next slide, which is, oh, can you go to the next slide? Thank you. IAP Worldwide, you went too far. The IAP Worldwide Services case. And this was one where the contractor received a notice to proceed to go to Pakistan. And what happened is Pakistan closed its border. And it's a really interesting case because it's just so vehemently for the contractor because the government just didn't act as it should have. And so it goes through all the elements of contractor excusable delay, which you would need if you have a problem with the pandemic. So good case to have just for that. And then it also goes through everything that the government didn't do to get the schedule adjustment and how it ultimately required the contractor to expend more time and effort, and it should have been given a schedule adjustment, but in that particular case, the agency just didn't do what it should have. And so if you're dealing with that kind of situation, this is the case that I would look to. So next slide, please. The other one that could be possible relief is the changes clause. And this is something that is generally found at FAR 42 or 52.243-1 and FAR 52.243-2. And that basically is where if because of the pandemic, and this is different from your job is harder to perform because of the pandemic, this is because of the pandemic, the government changes the structure of the work a little bit. And so it's a nuance, but basically if it's not just, it's harder for you to do something, but the government says, well, because of the pandemic, we want you to do X, Y, and Z instead. That would be a change. And if that's a change, then that's something that could fall under the changes clause. So if that's happening, then that could be something that is compensable. And again, as I've harped time and again, will throughout my entire practice in life, make sure it's in writing, make sure it's communicated to your contracting officer, and any costs and expense contemporaneously documented with the change. And that could be something that is compensable. But the long story short here is that the pandemic effects are something to be mitigated, because ultimately under the law as it is written and ultimately under your contract, if it's harder for you to perform because of the pandemic, as a general rule, you don't get more money. And so the important thing to do is to mitigate, prepare, and in the event you find yourself in default, have done what you need to do in order to protect yourself. And as we all know, we hate CPARS ratings, we hate bad ratings from the government, especially when it's something that we find is just unfair because of pandemic. But if you have that good relationship, I would just emphasize, sorry, I've been up since 2 a.m. watching the election, and then again at 7. I would just emphasize that the relationship with your contracting officer is so important here, because the government has these mechanisms at its disposal in terms of defaults and other legal protections in its contract, but it's the government that chooses to enforce them. So if you show them that you're doing the best that you can, they know they can't get anybody else, and you have an otherwise good relationship, then you might not have to deal with some of these issues because the government will choose to just work with you instead of doing something that it could have done under the contract. Next clause, next slide, please. This is another issue that I've dealt with, and I am addressing it because I feel that some of you are probably still going through this issue where when you bid on a contract, the nature of the contract changes because of the pandemic. And it's not so much now because the pandemic is still going, where if you're bidding on something now, you know, hey, there's the pandemic, and I would take this into account when I'm bidding. And that makes it more scary and more, it exposes you to more risk because we know that the pandemic is happening. So when you are bidding on a firm fixed price contract in particular, or an IDIQ where the government is giving you estimate quantities, you are assuming the risk. So if it turns out that you bid on it and then later on the contract isn't as profitable as you thought it would be, especially if it's a firm fixed price, you assume the risk. And so if the government says, well, I estimated that we are going to have, like, say, for example, a transportation services contract. We said we thought, 100 people a day, and it ended up being 20 because nobody wants to go outside their house because there was another surge. If you needed that amount, the higher amount, in order to make more money, and you're losing money because it's 20 versus 50, and you would make money with 50 but lose it as 20, then that's not something that can generally be rectified, because if it's an IDIQ in the contract, it'll say minimum quantity, it's usually like $1,000 or something really low. And it'll say that these are estimated only, it's the risk, and it makes it something that you need to take into account when you're bidding, because if the pandemic changes in general, I mean, I thought that we were doing better a month ago, and then now all of a sudden in Illinois, it seems like there's been more occurrences, and it just doesn't seem to be going away. We don't know exactly when we'll get the vaccine. Point being is that you're assuming the risk when you bid. So just know what that risk is, because if something happens later and the contract ends up losing money, then in general, you're not going to be able to recover costs, because one thing that can generally end up rescinding a contract is if there's a mistaken bid. And so some contractors have asked me, well, can I argue that there was a mistaken bid because, we didn't know that the pandemic would do this, but a mistaken bid in general doesn't cover a mistaken judgment. So if your judgment was the pandemic isn't that bad anymore, we're going to get 30 instead of 20, and then it ends up being 15, and because of that you lose money, that's a mistaken judgment. So that doesn't give you relief. And then mistaken bid, that is basically when it's mistaken judgment and then mistaken in calculation. I forget, but the other category is basically when it's a clear mathematical error, and so that's not really what this would fall under. So just as a cautionary tale, just be cognizant of the fact that if the pandemic gets worse, and because of that, the nature of the benefit of your bargain shifts. If you've entered into a fixed price contract, or you've bid on something, then it ends up putting you at risk. And even if, and sometimes, it's true that from a legal standpoint, you're at risk, but maybe they can work out a solution with you. Maybe they can give you a cost adjustment. They can work with you, because the reality of the situation is that you're the only one who can do what the contract requires, and it's just equitable. So even if there's not a legal mechanism, the contracting officer is willing to give you more money. They're able to invoke the changes clause, maybe just do something to work with you. That is something that can happen, but it's uncertain. It depends on the relationship with the agency. It depends on their needs. It depends on what's going on. And so even if that's something that can happen, the fact of the matter is that it's not something that's guaranteed. So just be prepared. And, again, the Boy Scout motto, expect the worst, or oh my goodness, expect the best, prepare for the worst. And so next slide, please. I think that I actually might be out of slides. Yeah, so if there are any questions, I can entertain questions, or otherwise I can certainly discuss a little bit more, just a bit of examples based on certain things that I've seen.
Sarah, right now we don't have any questions on the board. We encourage anyone to ask questions, but I would go ahead with some more of your examples while we wait.
Okay, sure. So one example that I found was when there was a delivery time. So say in this particular case, it was a grounds maintenance contract, and the contractor had a period of time to perform. And so there was a 1-month period by which to perform grounds maintenance services at a certain Army base. And so it ended up being difficult, because in that particular instance, there were social restrictions in place. So you had social distancing, you had the mask requirements, you had employees who were quarantined, you had employees who couldn't come in, employees who were worried about being sick. And in that particular case, the contractor was very proactive about telling the contracting officer about it. So the contracting officer from the very beginning was taking account of what the requirements were in that particular state for social distancing. And so from the very beginning told the contracting officer, we have a month to perform this. We don't know if it's going to be more than a month, but this is what is happening, and this is what we were doing to mitigate it. And so in that particular case, they had a good relationship. They sat down and they had a teleconference with the contracting officer, and they basically worked out a game plan. Because for the most part, I find that contracting officers, they don't want to terminate contractors for default. It takes a lot of work to re-procure a contract, and it takes a lot of work in order to get somebody in for substitute services. So if you can find a workable solution, for the most part, the contracting officer and the agency is willing to work with you. So in that particular case, it was even something where the contractor couldn't say it's going to take us 4 extra days. They didn't know because of the pandemic. And so they basically just said, this is what we're doing to make it as little as possible. And so in that particular case, the contracting officer was willing to do a no-cost time extension to the contract because of excusable delay. They had it in place. And then when they ended up defaulting, because they ended up taking the time, they were okay because they still fell within the original 7-day period. Now, unfortunately for the contractor, even though they didn't default and they didn't have to deal with a show cause letter or cure notice or anything like that, they did end up spending more money because they ended up having to take these measures, and these measures cost money to perform. So it's just kind of again, the effects of the pandemic, it's really all about mitigating. So in that particular case, the contracting officer worked with the contractor, they found a solution. Now on the flip side, if the contracting officer hadn't worked with the contractor and the contractor had, like say for an example, that the contracting officer said, we don't care, you're not giving us specifics. You're not telling us that you're going to be done in 4 days. We don't know if it's going to be 4 or 7, or we don't believe that this is the cause. And they weren't willing to work with the contractor. The situation that would have arisen there was the one that I was talking about earlier with constructive acceleration. And so that would have been a mess, because just inherently, even if you're right as the contractor and you've done everything that you can, just to deal with that is hard and it's problematic, because the contractor in that case would have ended up not having his mod and gone past the time. And so then he would have had to have proven that he had an excusable delay. He would have had to have affirmatively proven that he met all 4 elements, versus that contracting officer saying, sure, we'll work with you, rather than, did you legally prove every element? And then that the contracting officer didn't act. He would have to actually legally prove all of these different elements. And so this underscores the importance of just working with your contracting officer, because even if you are legally not completely, it's not completely a slam dunk, as long as they are willing to work with you, then you avoid having to deal with, I was terminated for default, should this have been legally sound? Because then you're actually held to the standard. And so just the main thesis of, I feel, this entire presentation has been document everything in writing and keep in touch with your contracting officer, because ultimately we're just trying to get through this together. And as long as you know your rights and you're willing to work with them and they're willing to work with you to a reasonable degree, there is a way out of it. It's just that don't expect to be able to recoup your costs, just expect to be able to get through the situation.
Great, thanks. Sarah, we've had a couple questions come in while you were explaining that. One from Stacy Betts: is there a reverse FAR clause if the government shuts down the project and you have overhead costs associated with the project?
If the government issues a stop work, or, I think you're talking about if you're terminated for convenience. So, there's a difference between if there's a stop work order, and then if there is a stop work order and there are additional costs associated with that, I believe, and I can check this for you and email you to confirm, but if that cost includes overhead costs that are attributed to the delay, then you would be able to get additional costs, because it would fall within the category of a cost that was caused directly by the delay period or by the stop period. So that's if they stop work and then they start it again under the stop work clause. And that stop work clause is actually in the presentation, and that should also say what the categories are of damages. But then also, if a project is terminated for convenience, that's a different category. So if you're terminated for convenience, where the government just basically decides that they don't want the work anymore, then there are procedures in FAR Part 49 that will discuss what you're entitled to, and overhead is one of those categories. So that's 2 different things that could happen from the government: stop and go again, or terminate entirely.
Okay, great. And we'll put your contact information back up and ask Stacy, if that didn't answer the specific details, to reach back out to you individually and get some clarification on that.
Well, what I can do is, any questions, I can email the attendees just to make sure that I'm clear and I've provided any information and
great, thank you.
The question.
From Michael Dillard, excuse me, there was reference to the Christian clause in a previous slide, and what was, if you could expand on what that relates to.
Yes, I appreciate you bringing that up. So basically, this is something that I was just thinking about in my practice. So the Christian doctrine is the idea that if there is a clause that is not in the contract, but it is a clause that is so important and common in federal government contracting that to not include it would preclude fairness in the contract, then it will be read in as a matter of law. And I've actually made that argument before, where if your contract does not have FAR 52.2124 or 52.24910, if it doesn't basically give you some kind of an excusable delay clause, like give you a way out if there's a pandemic and it's not your fault, I've made the argument that the Christian doctrine applies, and that just because of equity and fairness, the delay clause should be read, or the excusable delay clause should be read into the contract as a matter of law. I don't think that there is any case law that has developed that specific point in terms of just being fair to the contractor. Would a pandemic force majeure clause be construed to be written in? But I would be surprised if in this slew of upcoming cases that we're going to get at the Civilian Board of Contract Appeals, I bet anything that there's going to be a case that addresses that specifically. But I would certainly make that argument if you're encountering an issue and you're just making an equitable and fairness argument to your contracting officer about why they should work with you. I would reference the Christian doctrine if you're missing one of those clauses.
Great, very interesting, very helpful. We also had a question in the chat about whether the slides would be available, and Earl has included the link in the chat function there if you would like to click on that. That gets you direct access to the slides that have been spoken to, plus we will also have them on our website as well. Sarah, I think that concludes our questions. We sure appreciate your time. It's always so impressive to hear your wisdom and your knowledge of these things, and it's great to close out. Well, it's unfortunate that we have to close out a webinar series on this type of topic, but it's apropos that we do close out the webinar series on this topic, just because of the environment we're in and the conditions that our members and everyone else out there is working with. So we do appreciate the fact that you are with us and that you're our closing speaker for this webinar series.
Well, it's just so strange because with coronavirus, these questions are just so new. We're dealing with things that are common in terms of changes and equitable adjustment and delay. But I mean, just pandemic, just as an attorney, just researching these issues, there are things that are similar, but we've never been in this situation before. And I just think that that's why it's really going to be resolved between the contractor and the contracting officer for the most part versus battling it out, because it's just otherwise there's going to be so much litigation that people just don't want that. But I'm sure that it will develop further. So maybe there will be an update in 6 months from me.
Well, we sure thank you very much again for your time. We thank for those of you who joined us today. Please look for our announcements as we go into next spring and our next series of webinars. We're very excited about that. And we wish you all a happy holiday as we move into the holiday season. And again, next week, as we celebrate Veterans Day, God bless all of you veterans and veteran supporters and veteran business owners out there for serving in uniform and doing the hard things, and then being willing to trade that uniform in for oftentimes what is even harder, and that's being a business owner and working in the small business arena, particularly in the federal marketplace. You've chosen a path to serve multiple ways in areas that most people just don't have the grit and the heart for, and we certainly appreciate that and understand that. Sarah, thanks again. It's great to see you. We wish everyone a great rest of the week and a great afternoon, and we'll see you all around next time. See you later.
Thank you, everyone.
Bye-bye.
All right, bye. Thank you.